Welcome. In this session, we will explore if you were to post opposing or negative information on the Facebook page of either a child support worker or commissioner or executive, and whether or not that is covered by the First Amendment. As you know, social media provides a lot of information. We provide information to you via the YouTube channel. But in this session, let's explore that if you post a comment on a child support, either director or employee or a judge website, can you be punished or is it protected by the First Amendment? Let's get started. To review that question, let's look at a case law called Davis versus Randall, and it was decided on January 2019. And the question before the court was, does the blocking of a opposition or an opinion from the public on the social media page, in this case a Facebook page, if a government worker such as a child support executive or a judge or a commissioner? And in this episode we will explore that, because the answer is yes, it is protected by the First Amendment. So let's look further into this. As you know, we provide our information on many social media platforms. We have a Twitter location. We also have a Facebook and an Instagram. Hello, my name is Chris, and in this session, we will look at your First Amendment right as it relates to you posting either favorable or unfavorable information on the website or social media page of a child support executive or worker. The First Amendment, as everyone knows, guarantees what's called freedom of speech. And the question is, does that extend to social media posting as well? Again, here's our non-lawyer maxim, whereas we are also exercising our First Amendment right to provide you information regarding the child support program, and we are protected in terms of our non-lawyer maxim. And one of them is there can be no sanction or penalty imposed upon one because of his exercise of constitutional right. That's Shearer versus Cullen. We have here what is called our call to action page. That is where we provide tips and strategies on this topic of, can you post information on a child support that's owned and operated by a quasi-government worker. This decision comes from what is called the Fourth Circuit. I like to produce the circuit where these decisions are made because that gives you more sort of a credibility. And it's good to know which region of the country or judicial region that this decision was made. In the event that you're before a magistrate or a commissioner or a judge and they ask, where did you get that information? This decision in this circuit regarding whether or not you can post information on a Facebook page, you can also use that in other circuits. For example, I like to quote Howlett versus Rose, which is federal laws and Supreme Court cases apply to all state courts. You often hear a magistrate or a commissioner in child support cases saying, well, that was a decision of that state. This is a different state. Well, I love to quote Bullock versus U.S. that says states are bound by United States Supreme Court cases, all of them. They can't pick and choose the ones that they abide by. So let's look at the case itself. And it was brought by Brian Davidson and Phyllis Randall. And the issue was, can you post on the Facebook page of a government official? This particular brief was written by the American Civil Liberties Union, that's the ACLU. You may note it's a nationwide nonprofit, nonpartisan public group that its entire organization is to protect the Constitution and your constitutional right. The reason I mention is that they are not a party to the case, but they were allowed to provide opinion through what is called an amica brief. Let's look at the summary of their argument. The basis of their argument is that posting information on a public officer's website is protected by the First Amendment. What does that mean? And this is their argument that one, if a government official decides to produce what is called public information in the course of performing their duties, and they allow others to post information on their social media page, can they block anyone or any opinion that they disagree with? Second, does this constitute what is called free speech? And third, is it possible that once the page is published, can you then decide who or what favorable or unfavorable information is posted on that page? Further in the brief, it covers a topic which is important to point out. They looked at this issue through the lens of what is called color of law analysis. That is the 14th Amendment, state action, as well as 42 USC 1983. And in this context, they're saying an individual government actor, the test is under the 14th Amendment, as well as 1983 color of law. And they quoted Lugar versus Edmondson Oil, as well as United States versus Price. And what's good to point out is that they looked at the role that the person plays as an officer of either the court or a public official. Further on in the brief, they continue to say that you cannot separate whether you should look at the official capacity of that government official or non-government or quasi official, or their personal capacity, both of which can be put under scrutiny. That is, it's not necessarily that says the person is acting in their official role, but then that their social media page is an individual decision. Those two cannot be separated when looking at this from what is called Hafer versus Mello. Next is once the public official post or add public information to their personal social media page, is it protected, or can you use the First Amendment if they were to block someone from accessing their page, or prevent someone from accessing their page, or remove them from either a membership list? These are the foundation, the basis of this brief. In my opinion, the argument of this brief applies to all social media platform. That is, whether it's Facebook, Twitter, as long as it has a public access or public facing access, this decision of the court applies to all platforms. So let's look at the decision of the, again, Fourth Circuit Court. Let's look at it. And if you note in this lawsuit, they're both applying the official and the individual capacity. They're not separating it. Likewise, they're looking at the other officials who are involved in this case, both their official capacity and their personal capacity. So the issue before the court and in this lawsuit is, you could apply a 1983 deprivation of rights to this case. And that's very good because you can file a 1983 with regards to this issue. Second, let's take a look at the viewpoint, not of the platform owner, such as Facebook or Instagram. Let's look at it from the individual perspective. And that's critical to understand. They're not involving the policies and procedures as the platform decides. They're looking at it from the official, what their intent is. And they're applying the 14th Amendment and 42 USC. So the decision by the Fourth Circuit is this. If an official, let's say a child support executive, publishes information about their functions or form and they allow public access to that, and however, someone posts a negative opinion of that information or provide additional opinion, that individual cannot block that person. Because why? Because it's now considered a government, what is called public concern. And Judge Justice Barbara Keenan wrote in her opinion that the issue before the court, not whether you can post on a Facebook page or a social media page, the issue is look at it from the point of view of the public official. Are they using it in their individual capacity, or are they use it in their personal and professional capacity? The idea is once in government information is on that personal page and it is linked to the public, it is protected by the First Amendment. So here we are on our call to action page. And here where we give you tips and strategies for using your First Amendment right as it relates to public officials such as child support, staff, members, and executive. And this decision was a through what is called a unanimous decision from the Fourth Circuit. So how would you use that in your case, or how would you use a part of that? Now, understand this: we're not talking about providing false information or derogatory information or just quite offensive information on social media pages, because that is a policy and procedure of the owner of the platform. So we're separating the two. Okay, this is about just the information as it relates to the individual who has posted it on their platform. For example, we know that the President Executive Letter, Order 13563, clearly states that 1099 workers are not included in the child support program. But if a judge or a magistrate or an executive post on their personal media page, social media page, that that is not true, you can link that information so that others can view that. Now, I'm not saying copy it because there are copyright issues, but you can link that, yes, this is a true statement. Also, the rebuttal, in order for your intercept, in other words, to prevent the intercept of your stimulus check, could also be linked to that judge or that executive who claims that you cannot get back your stimulus check. Again, we're not talking about false information, negative information. We're talking about information that either rebuts or supports what is called a public access to a government official. Now, if you disagree with us in our opinion, and the reason for us broadcasting this particular episode is many of you would like to comment on a child support executive's social media page, but are afraid and believe that, well, if I do that, I could be punished or be reprimanded. Just understand that is not true. The First Amendment protects as long as you determine whether it's private or public. If you disagree with us, please send us an email, as well as we ask that you subscribe to our YouTube channel. Next, we ask for a donation of approximately $25 or any amount. That helps us in our research to provide you what is called selective material that could aid and support your attempt to separate from the child support program. Also, we provide here other videos that you could review to help you in your quest to leave the child support program. Thanks.